I'll go ahead and start it.
Hello, everyone. Thank you for joining us. We'll begin here momentarily. When Renee clicks open the doors, it takes a minute or two for everybody who is in the queue waiting to get in. So just give us another minute or so before we start the conversation. Make sure as many of you are in the room as possible. So I think we're starting to plateau for right now, Renee. And I think we'll get some more people who join us over the next 10 to 15 minutes, as always is the case. But thank you all for joining us here today, and thank you for being a part of this conversation. It is a conversation about trends in patent prosecution, and we're going to talk about how you can understand both what is going on at the office and to make sure that you can take advantage of this and internalize it into your daily practice, whether you're in-house or whether you are at a law firm, so you can help your clients. So Renee, why don't we, this is what we were going to talk about, but let's first, why don't we introduce the panel?
Sounds good. All right, so today we're going to start with Mercedes Meyer. She is a partner at Banner Witcoff, representing leading life science and technology companies, maintaining an extensive biotechnology and pharmaceutical patent management, prosecution, opinion, and due diligence practice. With a doctorate degree in virology and a degree in chemistry, Mercedes has a deep understanding of complex biotechnology and scientific research, which is key for advising life sciences clients on commercializing and protecting product innovations, as well as performing diligence for investing in new technologies. Next, we have Ted Wood. He is a patent attorney and owner of the Washington, D.C. based patent boutique law firm Wood IP, where his practice focuses on patent prep and prosecution, inter-parties review, re-examination, and appeals before the PTAB. He has also served as virtual in-house IP counsel for several high technology emergency companies. He has a Juris Doctorate from the University of Dayton, Ohio, School of Law, and a master's degree in electrical engineering from Northrop University. He's also a service-disabled veteran, having retired as a lieutenant colonel from the U.S. Air Force after honorably serving for 23 years. So thank you for your service to our country. Next, we have Savon Kalmanov. He is the director of Canon USA Inc. Intellectual Property Division. He is responsible for managing the division's day-to-day patent prosecution work, overseeing both the patent prosecution and administration departments. Savon also provides support on patent litigation matters, contract matters, and general U.S. patent law related advice to various domestic and international Canon companies and subsidiaries. He's a current member of the California Bar Intellectual Property Section. He has a JD and a Bachelor's of Science in Electrical Engineering. Next, we have Katie Brown. She's a customer success manager from LexisNexis Intellectual Property, who manages numerous customer accounts, providing training, and is the subject matter expert on LexisNexis's patent analytics solutions. Katie holds a Master's of Education degree from the University of Virginia. And finally, we have our moderator, Gene Quinn. He's a patent attorney and a leading commenter on patent law and innovation policy. He founded IP Watchdog in 1999 and since has twice been named one of the top 50 most influential people in IP. He is regarded as an expert on software patentability and US patent procedure, and has repeatedly been recognized as one of the top IP strategists in the world. So you have a great panel to listen to today. Back to you, Gene.
Great. Thanks a lot, Renee. And thank you all for being here. This is going to be what we're going to talk about, trends in patent prosecution. We're going to discuss insights and strategies and techniques and best practices. We have a lot in store for the conversation today, so I'd like to just jump right in. Savon, would you like to go first with your big picture? What is it that you want to make sure everybody hears today and we talk about today?
Sure. Gene, thanks. Good morning, good afternoon, everybody. My big picture is from a patent prosecution standpoint is just to try to understand what these emerging patterns are so that you can properly support your client, whether they be corporations or small inventors, just basically using and understanding the emerging patterns and how patent prosecution is going these days in order to best serve your client, whoever that they may be.
Great. Thanks a lot, Simone. Ted, your initial thoughts first today.
Thanks, Gene, and good to speak with everybody this afternoon. My big picture is being able to leverage big data and data analytics to make patent prosecution a more deterministic, a more predictable experience. Being able to peek behind the curtains of the USPTO and understand how some of the decisions are made based on data analytics.
Great. Thanks a lot, Ted. And Mercedes.
I think importantly for me is data analytics won't take your job, but failure to understand, use, and implement data analytics may cause you to lose your job. So, get with the program, know what analytics are out there, and analytics are evolving rapidly.
Yes, they certainly are. That is an understatement. And last but certainly not least, Katie, your initial thoughts first today. Big picture, what do you want folks to focus on?
Yeah, thanks, Gene. I would say, like the panelists have mentioned, the importance of using data-driven insights to understand not only larger trends over time, but also specific differences in prosecution, both by art unit as well as by the examiner you're dealing with, because when you really dig into those stats, you can see that there can be some big variations which can really affect your success.
Yeah, no, absolutely. I mean, and I'm just going to echo my big picture thoughts on that. I don't understand why everybody's not using this. And the reason is simple. Like the way I view the world is different than the way that each of our panelists views the world. And on some issues, I may be more a stickler for the rules than on other issues. And that's just the same with examiners. There's 8,500 plus or minus at any given time examiners, and not knowing whether you're working with an examiner who is likely to issue the case or not is beyond me. And two, when you drill down on what the information that LexisNexis can provide, for example, you can tell at what decision points, inflection points during prosecution is an examiner who is likely going to issue a patent, more likely going to do it. I mean, are you talking one RCE? Are you talking two RCEs? Are you talking maybe after you file your brief or after they file their answer? What are the moments in time when you have the greatest opportunity to reach out and convince the examiner? I mean, these are critical insights. And then the one that has always killed me, not to give anybody bad names, but when you look through, so the guilty can remain anonymous. In other words, when you look through some statistics, you see there are some companies and there are some firms that will file like their 5th, their 6th, their 7th RCE, and dealing with an examiner who after the 2nd RCE, their allowance rate goes to 0 or approximates 0. So what are you doing? If the case is that important, you got to appeal it. And if you're just filing these RCEs in order to keep it alive, well, then appeal it, for God's sake. I mean, it's in the long run going to be cheaper to keep it alive on appeal, park it on appeal, that sort of thing. So a lot in store for us today. Katie, I know that you have prepared some slides with some new information that I think it's brand new as of like today. Mm-hmm. Lexis has published some stuff. So why don't we start with a conversation about fast track, and I'll kick it over to you.
Thank you very much. Yes, so, and I think we'll talk about this as an example of a trend and an insight that you can get using Patent Advisor to understand and to improve your chances at succeeding in prosecution. So I looked specifically at fast track applications as a possible, just to see what the trends are in this area right now. So when I was doing my research, I was looking at fast track applications, which include track 1, accelerated examination, as well as the patent prosecution highway. And I did, when looking at these larger trends, I looked at published applications that have been filed since October 2018 to get a robust enough data set, but also a recent enough data set to really understand what's happening recently with fast track applications.
Okay. And what did you find?
Yeah, so essentially was able to find that fast track applications overall, big picture, can be very beneficial, especially in terms, they actually really can increase your allowance rate. So I did this research across the technology centers. And what I found was that there was an increased allowance rate across all of them. Actually, the technology center that benefited the most was 1,600 in terms of allowance rate. When we were looking at fast track applications, the allowance rate was 85% versus just 70% without any fast track option being used. Additionally, on the flip side, and I know we have panelists who represent these different technology areas, so it'll be interesting to hear their experiences. But I did find that the least beneficial was computer architecture and software for 2,100. It still was beneficial, just a smaller difference of 93% allowance rate versus 88.
So there are differences here, and it is significant. And regardless of the significance, in your next slide here is this decreases prosecution time, and therefore it is also going to decrease the amount of interactions with the examiner, which is going to save money.
Exactly. And another thing I did find is that it actually didn't decrease on average at a higher level the number of office actions, but it did significantly decrease prosecution time. So of course, allowing you to get to your disposition much more quickly. Specifically, the technology centers that benefited most in terms of time savings were actually 1,700 chemicals and materials engineering and 3,700 mechanical engineering. So I thought that was interesting, kind of a different group from the group that benefited from a allowance rate perspective. They did receive both a first office action, so the examiner got to it more quickly, as well as a final disposition 13 to 14 months faster on average than those that didn't use fast track in those spaces. And then the groups that benefited the least, the areas that benefited the least were 2,600 communications and 2,800 semiconductors. However, that's just comparatively. They still definitely benefited a lot in terms of time savings of about 10 months, both to receiving both a first office action as well as getting to that final disposition. So definitely, as the name would imply, these fast track options really do save you a lot of time.
They really do. And before I look to the panel for some of their thoughts, let's go through a couple more of the slides. The trends in utilization, what did you find here?
Yes. So in terms of the areas where fast track's actually being used, it's used the most back in 2,600, which again benefits the most in terms of allowance rate. 8% of all applications are using fast track, and then it's the least utilized comparatively in semiconductors, with just 3% using it.
Okay.
Additionally, in terms of overall changes over time, in terms of, so I mentioned on average, not a significant difference in number of office actions between with fast track and without. And then looking specifically in 1,600 here, the most utilized area of this, and I know Mercedes' area of expertise as well. The average number of office actions in fast track cases has increased over time, but I would say, and it's increased quite significantly from 1 all the way back about 5 years ago, all the way to almost 2 for both patented and abandoned. So it's definitely gone up quite a bit, but this may be in step with overall increases in numbers of office actions in this area in general.
Yeah, let me stop there and bring in the panel. And obviously, panel, anything that's been said so far would be fair game. But the one thing that I'd like you to focus on, if you have some experience with this, is the number of office actions. And is this not just a trend dealing with fast track, but is this a trend across the entire office? Because I do think fast track still saves you office actions. It's not as meaningful maybe as it once was, but it seems to me that we're getting a lot more office actions and of much greater detail than we've seen in the past. So, Savone, your thoughts?
Yeah, I mean, we've seen an uptick in the number of OAs. The main issue we're dealing with is, I mean, I'm sure others are too, is really the quality. We're seeing some really bad OAs, and I don't know exactly what the issue with that is. And from a fast track standpoint, yeah, I agree. I don't know that that's how much that has any particular play in it. But getting to your immediate question is, yes, we've seen an uptick in the number of OAs. And, again, the contents I've seen vary from very detailed, as you indicated, to kind of not so good. And unfortunately, we've fallen into the tech centers where really fast tracking is shown to be the least beneficial. So, and obviously we've been dealing with a lot of the 101s, which again, I don't know how I'm not sure how the fast track would impact necessarily having to deal with the 101 rejections that we've been seeing.
Yeah, well, I was just going to say, well, certainly dealing with cameras, you can't be having any 101 rejections, right?
Oh yeah, never seen a 101 rejection that's based on a claim that's purely hardware. Never happens.
And I know you're tongue in cheek there, because I know that you have actually, right?
Yeah. Yes.
And
right.
I still don't understand why. I think the rule should simply be is if we could throw the invention at your head, and if you don't catch it, it leaves a mark upon impact, then it can't possibly be abstract. But that, for some reason, is not the rule. All kinds of things that are real, tangible, that actually exist are abstract. And I guess I just don't know what that word means, or maybe Webster's needs to update the definition, but we'll see if we have time to come back to that. Ted, your thoughts on office actions generally?
Generally, so we don't do a lot of fast track applications, but what we've noticed with those that we do file is, we're seeing more office actions, but we're also seeing more first action allowances through fast track. So going back to what Katie said earlier, one significant benefit, statistically significant, is that there are higher allowance rates for these fast track applications. I mean, there are various theories as to why that's the case, from examiners paying more attention to dockets that have these sort of high priority items, to less rigorous examination, better prepared applications. But those are trends that we see.
Yeah, there's probably a little bit of a lot of things that go into the increase in allowance rate, but it is significant, and as we saw in 1600, it's a 15% increase, and clients like patents. So if you can do something to help them get patents and get them quicker, you don't always want to get the patent quicker. I understand that. Like in the pharmaceutical area, you probably go with a longer, slower prosecution timeline, but in a lot of areas, the client needs the patent yesterday. And in those areas, you really ought to be thinking about fast track. Mercedes, your thoughts on anything that's been thrown on the table so far, not to pigeonhole you.
So with fast track, we've been really lucky on fast track, using it in, potential litigation practice, coupling it with examiner interviews, really useful. But use that analytic, whether it's Patent Advisor or something else, to figure out if that examiner responds well to interviews. A lot of examiners do respond extraordinarily well with an allowance as the next action, and much to everybody's annoyance, when you have that interview, a lot doesn't go into the written record, and you can push out that allowance a lot quicker. And you might even, if you ask initially with the fast track to have an interview quickly, you may be able to get that first action allowance. Having that really short prosecution history can be huge, but it also can be huge if it's a startup client and they're looking to impress the bankers to be able to get more funding in the door, and you need that rapid turnaround on a patent allowance. That can be important and worth the money, of $2,000 for that track one, or even, track one's not the only option. Pharmaceuticals, we'll show you some stats later that show PPH doesn't really work as well in 1600. But, if you have that inventor who's over the age of 65, it's completely free to do a petition to make special still. And that's beneficial. And as expected, nobody's using the accelerated examinations, which are still out there, because of the ESD, the express suicide document, for those who recall that language.
And they never, they were never satisfactory. You know, I know people that ran search firms and they were always getting their searches rejected, you know, and it's like, well, okay, well, that's so,
Yep.
yeah, you want to, that just never worked out. We do have a comment here about what I said. If what's thrown at your head is just off the shelf, it doesn't matter when it hits you. If it doesn't matter what hit you if it didn't add to a practical application or something more. And that's just simply nonsense, I'm afraid, because with 101, the question is it abstract? And if it exists, it can't be abstract. And if it doesn't add significantly more, or doesn't have a practical application, the practical application is supposed to be under utility, and the something more enough is about novelty and non-obviousness. And therein lies the exact problem that I have with the way that examiners are applying 101, and the courts as well, is and the Supreme Court particularly overruled Diamond versus Deere, because in Diamond versus Deere, they said specifically not to drive all the analysis into 101, and it will let 102, 103, and 112 do their work. And now what we have is a 101 that drives everything in the 101, and things that are clearly not abstract are rejected as being abstract. And I think that that's a big problem with the office actions that we get, because they're just, it's like Monty Python. You know, it's, you know, how do we know whether a witch is going to float? Well, let's weigh a duck, and then let's just weigh a witch. And if the witch weighs more than the duck, then she's a witch. And I mean, you know, remember that scheme. It just seems like there's an awful lot of stuff that doesn't make an awful lot of sense. And I mean, it doesn't have to become a 101 conversation, but Saman, you did tee up the question about whether or not some of these office actions are of a high quality. And I think that a lot of cutting and pasting makes some of these 112 rejections, where you get 18, 20 pages of 112 rejection, can explain. And I also see across technologies where if you say it once in the specification, but you only say it once, the examiners will reject it because, well, you only said it once, there's no written support for it. Well, but I mean, that belies the fact that it was said once. And there's I see an awful lot of nonsense. Do you, I'll start with you and go through the order again. Savan, do you see a lot of that kind of nonsense, and how do you respond to it?
We do, unfortunately. And, you know, unfortunately, it actually makes the response harder. I prefer to see a well-written, well thought out rejection, because it makes the ability to respond that much easier, at least for me. But yes, we have seen a lot of nonsense, and unfortunately, you know, we have to kind of go through it. And as indicated, I think Mercedes mentioned interviewing. I think in some cases, the only real way to get through it is to call up and try to talk to the examiner and try to understand, you know, what the examiner is thinking.
Yeah. Ted, what are your thoughts on, I mean, I'm sure you see some things that are not logically sound, but may be exactly correct legally. How do you respond to those?
So one of the tools that we like to use routinely, and, you know, there's a lot of the data that substantiates, as you were talking earlier, that a lot of examiners respond favorably to this. So we use, to the extent possible, examiner interviews, like right away, to clarify that language, you know, because we've got to be, you know, prosecute efficiently. So we don't want to waste a prosecution cycle or an office action response kind of guessing at what the examiner was trying to intimate. So we, you know, liberally use, you know, just a quick phone call to, you know, full-blown examiner interview for clarification. You know, that's one of the tools that we liberally use all the time.
Yeah. Mercedes, your thoughts on responding to these office actions where, you know, what's written doesn't seem to make a lot of logical sense, but maybe actually keeping with the law?
I mean, they vary all over the place. A lot of it is looking at the statistics for the individual examiner and figuring out, you know, certainly if the examiner has perhaps less than a 10% allowance rate relative to other examiners in that same art unit, figuring out whether you want to bring the SPE into this or the TQuas. Again, you're having to advocate for your client. I'm an outhouse attorney. I'm not in-house. And you have to advocate in a fashion that is fiscally responsible. So bringing in the supervisor, and saying, look, I have a 51-page single-space advisory action. I think that there's possibly something wrong here. Can we have some adults in the room to help, push things forward? Not saying the examiner is incorrect. The examiner has meritorious arguments. However, there may be a little hostility based between the client and the examiner. So how do we move forward? And that's been really successful. It's also been successful to take it to a SPE and an ombudsman and say, look, we're having these issues with this particular examiner. How can we move forward? No case in front of this examiner for this client has ever been allowed. And oh, by the way, her allowance rate or his allowance rate is X%. It's not going to be easy, but I will also say thank you to the SPEs that do help you. Take it to the director, take that, kudo up the chain, because their time, can perhaps be better spent. And this is not easy for them, especially if they're fighting issues with respect to POPA, the union, for specific individuals.
Yeah. So we, you teed up what was next on the conversation for, the know your examiner, which we'll get to here in a minute. We have in the chat an interesting conversation going on with a former examiner who said that she was told that she had to have a 101 rejection in every office action. And, and you hear about that a lot. You also hear in the means plus function area, if it can be interpreted as means plus function, you have to include a 112F rejection, and regardless of whether it makes any sense or not. And there's a lot of that goes on in order to, I think, force applicants to take a position. And that also underlines the importance of interviews and getting on the phone and having conversation with the examiner to figure out what is real and what is kind of not real in their mind, and what are the key issues that need to be addressed so that you're not just losing an office action for no reason. You may focus on the one-on-one stuff when in fact the examiner just put it there because they had to, or the means plus function when they don't really think it is. Examiner interviews, I think, are critical. But Katie, the examiner distribution, the lottery, so to speak, what do you want to tell us about this slide here?
Yeah, this is a good segue into this. So I was taking a look to see, are there different kinds of examiners that are assigned these fast track applications? But I just want to give a little bit of background here. So in Patent Advisor, we have the examiner time allocation metric. It's our metric, and we believe the most informative metric for predicting examiner behavior. Essentially, it's a calculation of office actions per allowance that the examiner is granting, but then we do factor in some other calculations as well, like their pending docket, as well as their time spent at the PTO, because what research has shown is that more experienced examiners tend to work through their cases more quickly, have fewer office actions than those who are newer. There could be various reasons for that, but that's included in our calculation as well. And so when we actually look at this, so of course, as Mercedes was mentioning, you're able to see the individual examiner statistics to get a better understanding of how will prosecution go with this examiner? How do we best get through this? What strategies work well? What's our success rate with interviews? Things like this. And then at the technology center level, we can actually see the distribution of those examiners. And so we classify green examiners as maybe not necessarily the easiest, but fewest office actions, quickest prosecution. And then the flip side, red are the toughest. Prosecution may be pretty difficult, and you may need to pursue some other options when going through prosecution with his examiner, like maybe an early appeal, something like this. So I took a look at the distribution of ETA scores across the Technology Center 1600, just to get an understanding of what that distribution looks like overall. And then in the next slide, I just did some quick research to see if it's actually different examiners, a different distribution of examiners who are getting these fast track applications. And what I found is that there's actually no significant difference in the score ETA difficulty score distribution between the fast track applications and overall. There was actually a slightly higher share of applications handled by yellow examiners, which are the more middle of the road examiners. And actually fewer handled by green, with little difference in red. So yeah, so use Patent Advisor to understand overall the distribution of the examiners and the difficulty of that technology center, and then to see if there was a difference in the way that those applications were being assigned to examiners for fast track applications.
Yeah. See, and that interests me, because what I've always been told is that there's a rotating basis. So it's just like, the next, but this would suggest that it's not exactly a rotating basis.
Potentially. Yeah, and I had read something that there was someone had thought maybe more experienced examiners were getting the fast track, which I think would tell me there would be more green examiners on the cases. That wasn't found either.
Mm-hmm. So in the green, red, yellow, that does not indicate, for example, allowance rate. That indicates speed to office action, correct?
Yes, it's office actions per allowance. So
yeah, and it just turns out that often is a very good map towards whether you're going to be able to get an examiner with a high allowance rate versus one that's sort of middle of the road in yellow, and then a really lower allowance rate or non-existent allowance rate in red. But you want to check both the speed, because there can be some one-offs here and there where you have somebody who's fast but fast to reject, or they're fast or they're slow but they'll allow. But ordinarily green is higher allowance, yellow is about middle of the road, and red is at the bottom. But that's not what the metric is about. It's about speed. It's about how fast are you.
Right, exactly. And how many office actions do you have to get through with his examiner to get to that final disposition? And yes, times a calculation. Yeah.
Right,
exactly.
right. Okay, so any thoughts on this? I know I can see both. I think all of you are conversing with attendees in the chat box. Is there anything to say here on red, yellow, green, or anything that maybe you've shared in the chat box that you want to make sure we kick around out in the open? Anyway.
I don't have anything, Gene.
Okay, Ted?
Yeah, so one of the questions was the success on appeal of turning over sort of bad office actions. We've had some very good experiences with the ombudsman reaching out to SPEs, and that's that path is not always successful, but when it is, it's quicker, more efficient, it's a lot cheaper, and we've gotten some really good outcomes, especially when we unpack an office action and we find out it's a red examiner. And as I mentioned earlier, we have to be one of the unluckiest law firms, because we've had a number of examiners with 0% allowance rate since they started at the PTO in 2015. And if you haven't an office action like that, it's like senseless to simplify a response. And so we use all of those tools to kind of set the stage and manage expectations.
Yeah, and I just want to follow up on what Ted and what you said in terms of using the ombudsman. That's definitely, something that we do look at and we have used, and I would recommend that people consider that, especially when, if you've kind of gotten to the point where you're not getting anywhere with the examiner or the examiner's SPE. Then the ombudsman is something in the toolbox to think about. Unfortunately, they're sometimes not very quick to get back to you. So just keep that in mind if you're dealing with a time sensitive matter. But again, Ted, I totally agree. The ombudsman is definitely something that should be used depending on the situation.
Yeah.
Yeah, I've used the ombudsman in the past and had very good results on. They're not able to help you with substance. So like in the conversation we were having, for example, about this should not be abstract. That is not an ombudsman issue. Ombudsman deals with process and procedure. So you have to make sure you can couch it like that. But like, and we had a comment here, how do you get the SPI involved? Well, if you're not able to get a decision maker to call you, I mean, the patent office, they're supposed to, I think it's 24 to 48 hours is what the goal is. And, you call, you leave a message and you don't hear for a week or 2 weeks, or that's precisely the type of thing an ombudsman can help you with. And if you want to get the SPI involved because, the examiners indicated that they're rejecting you because the SPI has told them to do that, or they're a junior examiner and you're never able to actually talk to the person who has decision-making authority, those types of things, maybe you can get help with the ombudsman for, but it's process, not substance. But still, there's an awful lot of things that you can characterize as this is a procedural irregularity, and get help. Mercedes, any thoughts?
Yeah, I'm trying to keep track of all the questions and everything
Yeah,
else.
we're touching a nerve here today.
You think? I think one of the things is also looking at pilot programs, and whether the pilot program or whether like a pre-appeal brief conference is going to work with that particular examiner or that particular art unit. If it's not going to work, don't bother. I find this is especially true with working with Japanese clients. They'll be like, well, we heard about the AFCP 2.0. Can we use it? And I'll come back with a report saying, yeah, it's a really good program, but it's not going to work with this particular art unit. I think the other concern is, yes, you can do great on appeal sometimes in turning things over on appeal, but then there's the examiners and art units that don't let anything go up on appeal. And you can see those statistics too, where you then have to say to your client, okay, getting this case to appeal is going to be difficult.
So what do you do, Mercedes? What can you do in that situation? I mean, I have some thoughts, but my thoughts are probably pretty draconian, I suppose. So what do you do in everyday practice? I mean, because you can't go to the mattresses every time that happens, because it happens a lot.
I actually have not had it happen where I really, really, really want to go on appeal, and couldn't get there. So, I'd love to hear your thoughts on that. I was just gonna couple other points for the ombudsman, really keep it procedural. Like if you've requested an interview and the examiner comes back with an office action and did not call you back for an interview after you filed that RCE, go to the ombudsman. Make sure it gets up to the MQAS. That is a procedural thing that they should get dinged on. There was a question on 112 issues. I think the 112, I know that the examiners for a while had a program or an analytic to look at claims for antecedent basis and maybe written description. I don't think it's getting utilized very much. Pick your poison on how you respond to those 112s. But after IPO, what I've been told is, get ready, folks. 112 is the new 101. So we're back to 2000 and 2001 Space Odyssey and the written description and enablement guidelines.
Yeah. Stay tuned for more.
Please share. I want to hear what you do.
No, I mean, what I will say, so Jennifer in the chat says that she just continues to refile the notice of appeal without any comment. I mean, that's a decent strategy. I mean, the problem is if you have an examiner, if you really, really want to appeal and you have an examiner, and David asking the question, well, how does the examiner make it difficult to appeal the case? They just keep reopening prosecution. And then they get you into this never ending cycle of never letting the case mature to the point where they're going to actually do an answer. And a lot of times when it reopen prosecution once, it's like you think, and you're dealing maybe with a reasonable examiner, you're thinking, okay, well, maybe they were about to write their answer and then they realized that there's a problem here. So maybe there is an opportunity to work with that examiner. So you don't necessarily think that just because prosecution has been reopened, that you're going to be dealing with an examiner who's going to shut the door on you and it doesn't want you to go up on appeal. But there are examiners that are like that. Now, like all situations in life, it seems the small minority give the majority a bad name. So this is not, I think, commonplace. But there are examiners that I hear, and as you probably imagine, I hear the stories about the underbelly of the practice. You know, people want to really appeal. There's a fundamental disagreement with the examiner or with the art unit, and the examiner just keeps reopening prosecution and won't let it go forward. Well, I mean, as good a place as any to start is with the ombudsman. But at some point in time, if that is what's happening, you are going to need to call and get in touch with people in the commissioner's office, because the commissioner's office is the one place that they do have more authority than just the ombudsman. And you know, I don't know that this is still the case, because I don't know the person who is in the commissioner's chair at the moment. But when it was Drew Hirschfeld, when it was Bob Stoll, when it was Peggy Focarino, and going backwards all through these people, they would tell me, and they would come on our webinars and our programs asking for information about irregularities, because they would all say the same thing. Drew Hirschfeld, I know he was last in that chair before the current occupant, so he would constantly say, I can't fix things I don't know about. You know, so if you're having problems, and you all are adults and you've been doing this for a while, you know when it's an irregularity, you know when you really want to appeal and the examiner just keeps reopening prosecution so you can't get the critical issue addressed. Well, call the examiner or call the commissioner's office. If the SPI is not helping, if the group director is not helping, and the ombudsman is unable to help because they don't view that as a procedural issue, you may have to escalate. And the thing that I hear all the time from people is, well, that's going to ruin the relationship. Well, in certain areas of the office, let's just be honest, you have no relationship. When you're dealing with an examiner or art unit that is single digit allowance rate, or the examiners that we've alluded to that haven't allowed a case since Alice, and there are some out there, you don't have a relationship with that examiner, you know, or the relationship is akin to a hammer and a nail. You know, the nail, I don't think feels like they have a relationship with the hammer. You know, so you may have to break through and do things that are uncomfortable. And then if it becomes extreme, I mean, you know, the federal circuit seems willing to entertain mandamus about anything anymore if they think that the underlying decision was incorrect. So I'm not going to suggest that you do that, but there are things that you can escalate if you really want it, and if it will filing a notice of appeal wasn't just for strategic posturing or keeping the timeline alive.
So, and Gene, I'll add one thing to that. You know, we've had, for lack of a better way to say it, all ombudsmen are not created equally. So we've right. actually had ombudsmen to look at office actions and issues on the merits, and you know, and make a determination that, well, yeah, it looks like, you know, this examiner is wrong. And in fact, we have a matrix that we put together of when we reach out to the ombudsman and when those issues are beyond you know, merely subjective disagreement. And you know, we've had, you know, experiences where the examiner, especially with a junior examiner, where the ombudsman has overruled the examiner on the spot. Of course, we've had other cases where we get kicked around. Hey, talk to the SPI. You know, the SPI is moved on to a different unit, and you know, 2 months later, nothing. But yeah, we've had some remarkable experiences with the ombudsman's office.
Yeah, and you're never going to know if you don't try, right? You know, and what often the ombudsman can do at a minimum, even if it winds up being something that is on that line of procedure and merits, or maybe it's just clearly a merits issue.
Yeah.
If the ombudsman really wants to help you, if the ombudsman thinks you're getting jerked around, for lack of a better way of saying it, the ombudsman can at least get a fresh look at that and contact these people and say, hey, can you take a look at this? You know, and sometimes that's all it takes, you know. And if it's you know, don't forget your human skills, right? You know, it's like are you really going to make me appeal this? Do I really have to go through the several years wait, the filing the appeal brief? And when this is not what the entire rest of this art unit is doing, and it's just not correct. I mean, can we get somebody to take another look at this?
Yeah.
And often the ombudsman will say, well, let me see what I can do. And they will come back. And in my
Yeah.
experience, sometimes they're able to do more than what you ask them, because you may be limiting your ask because of process versus merits, and they do come back with more for you. They're there to help, you know, and as Ted says, they're not all created equally. And I'm not to say any one ombudsman is bad. Some of them just have a more narrow view of what the role is than others. All right. So looking at the time, we probably want to push on. There's a couple more slides I want to get to here. This is Katie. What are we looking at here?
Yeah, so this is basically just, and I won't read out every single stat here, but basically just emphasizing the point which Mercedes was really talking about when we were thinking about this talk is not only at, you know, do you want to see the trends at a high level, but you also need to kind of dig into the statistics based on the art unit you're in. So if you compare these different art units, there are very different outcomes, both in terms of overall allowance rates, as well as use of various fast track strategies. So you can see there's a breakdown of accelerated examination, track 1, patent prosecution highway, as well as the petition to make special based on age or health. And so you can see the number of cases really vary. The allowance rate really varies as well. So just wanted to share all of this and emphasize the fact that that's why it's really important to be able to dig into the statistics that are relevant to you in terms of the examiner you're dealing with, the art unit you're dealing with, as well as the strategy you're using.
Yeah, you know, and I think that this is gold because, you know, not all clients are going to let you do these various, let's call them exotics. But, you know, if you look at this and you say, look, a petition to make special in 1641 is going to lead to 92% allowance rate, generally speaking, you know, well, then let's file the petition to make special there. When you look at, you know, PPH, 84% in 1621, you know, I mean, these are valuable insights. And if you're armed with this and you can show the client the benefit of it, then you're probably going to get more uptake than if you say, well, I think this is going to work. Well, no, we know that this is going to work. And here's how we know it's going to work. Then we have litigation outcomes here.
Mm-hmm. Yes. So essentially, basically the finding was that, again, using 1600 as our example, fast track applications, maybe just because of the technology it is, maybe these are really important patents, more, I guess, I don't know, fought over is probably not a good word, but yes, they do. There's a higher proportion of them that do get involved in litigation, 6% versus 0.4%. But also I've found that there's a higher level of them being upheld. So patent owner win rate is higher in these litigation proceedings for those that have been on fast track versus without.
That's good information too.
Mm-hmm.
And then your last slide here.
Mm-hmm. Mm-hmm. Yes. Also that almost every technology center, I just thought it was an interesting finding that the chances of winning on appeal are actually lower for those that have fast track. Biggest difference was in 3600. Chances of winning on appeal with fast track was 59% versus 72% overall. And we calculate winning on appeal. It's pretty broad, but it's basically saying the next outcome after each appeal step. We have very in-depth stats on this. And a win is considered either an office action or an allowance following appeal. So could vary whether or not you consider that a win. And then a loss is an RCE or an abandonment directly following an appeal. Also found, and of course, this is where we'd have to dig into those statistics further, but the applications on appeal in 3600, of course, that's a tough area, did have a higher prevalence of the 101 and 112 rejections than others.
Yeah, well, you know, this would suggest that together with in the previous slide where we say that the litigation, the outcomes are less or are invalid, I guess, or have a higher success rate, would suggest that in the fast track, there is either actual better consideration or a perceived better consideration that plays longer than just that particular case. So when certainty matters and making sure that the patent is going to stand challenged, then maybe fast track is good for that reason in and of itself. All right, so we have two more slides. This slide, Ted, has a bunch of your additional thoughts if we had time to get to them. Maybe we could have you pick out one of them. And I apologize, these are not supposed to all be numbered one. I did everything I possibly could to get the format, and it still didn't work. But which one of these do you want to quickly talk about, Ted?
So I would say leveraging firm statistics for marketing. Because we're a small firm, we don't have the instant name recognition, but we have a lot of experienced attorneys who have worked at the Am Law 100 firms and, at a different point in their career. So we have a team of very experienced prosecutors, but just saying those words to clients is not enough. And so a lot of this data can substantiate comments that we make. For example, dealing with red examiners, right? There's statistics that show how firms do in dealing with red examiners, yellow examiners. And, I'm sort of an adrenaline junkie. And so when I see, a tough case, 100-page spec that wasn't written that well, we sort of roll up our sleeves, kind of an all hands on deck, and really put a lot into that case. And it shows in the data that statistically, by a significant amount, we do, in comparison to other firms, have, higher success rates with red examiners. And the claims that we are able to allow typically have fewer words than that particular examiner will typically allow. So those are the types of areas where we use these statistics and data.
Yeah. So one thing you mentioned there, Ted, I think I heard you say, like if you inherit a case and you have a specification now you're prosecuting, and that reminded me of a comment that was made in the chat about when you get these 112 rejections, are you better off to amend to appease the examiner? And one strategy, I know somebody who does a lot of prosecution, actually, John White, who many of you know, he teaches the patent bar review course. He quote unquote inherits, because he does a lot of prosecution for his firm, applications written by others and applications from outside the firm that then come in, that then he winds up prosecuting, sort of one of the patron saint of lost causes, which is sort of what you were just describing there, getting a lot of red, right? And his strategy is, if the examiner has a problem with a certain phrase or doesn't know what certain things mean, he'll say, well, I had the same question, examiner. Let's just get rid of that. How about we use this term instead? And you kind of co-opt the examiner to be on your side to figure out what term they're comfortable with, rather than, getting, the hair on the back of your neck standing up and say, well, what do you mean you don't understand what inverted says?
Exactly.
Inverted is inverted. Look at a dictionary, damn it. That's usually not a winning strategy.
Yeah. In a negotiation, that, you have to have something to give away, to give up. And those things don't have, typically very few adverse prosecution consequences. When you negotiate it, just like you said, you find an acceptable term.
Right. So Mercedes, this is your slide here. Do you have one thing here that you would like to pick off in the last few minutes we have?
Oh, they're all so awesome.
I know they are.
Okay.
You mentioned the use of pilot programs already.
Yeah, but we can skip that. I think for opinions, if you're analyzing a particular application, these analytics, and there's a bunch of them out there, whether it's, Optimizer or looking at PatSnap and Total Patent, you can look fairly quickly at the written description and definiteness of claims. And it, in 60 seconds, you'll get an idea of, is there a problem? And then you can go back to your client and say, do you want me to write this up or not? Frequently, they just want to focus on 102 and 103, and they'll say, throw it in a footnote. It can also give you quickly case law on specific terms that you wouldn't have otherwise found. And I have found useful case law in those instances, like for ratios and certain other things that I could then apply to my opinion based on specific terminology in my claims. So, there are tons of analytics. They're constantly refining and changing. The 112 written description definiteness and finding that the terminology for opinions really helpful.
Great, good stuff. This is great stuff. Savon, I know you don't have a slide here, but you are the client, so you have the opportunity not to. You want to play Monday morning quarterback with anything that has said? What do you like to see when from the attorneys that are working for you?
Yeah, no, I think the points that Ted and Mercedes made based on their charts are somewhat also applicable to us. For me, if you go back to Ted's chart, everything on there is really relevant except for obviously the marketing, since we're not in the, I don't have to market myself. We have built-in clients, but it is something that, to use the tools and the data analytics to determine, upfront before you file, is to, make sure that I have to make sure that my business units understand where we're going and what potentially could happen, since they're on a limited budget. But then also all of that data comes into play afterwards when we do get the OA, so that we can properly inform them, where do we go from here? So, so that way, it's a beginning and a middle, so to speak, in terms of, being able to use this. So again, I think both Ted and Mercedes comments and charts are very applicable.
Yeah, no, great. This has been great stuff. We have just a few minutes remaining, and I'd like to go through and give each of you an opportunity to wrap up with final thoughts. We can go in the order in which you were introduced. So, Savon, how about your final thought?
Just my final thoughts. I'm just gonna kind of circle back to what my original thoughts were going in, is, to make use of whatever data that you have available in order to, keep your client appraised of what's going on, but not just when at the office action stage, to figure out, how am I going to react when this examiner gets it, but also upfront to understand where this application might end up, so that you can potentially craft the claims and the applications to try to avoid potential issues down the road.
Great. Thanks a lot, Savon. Ted, your final thoughts.
Yeah, there's a lot of data out there. There's a lot of sources for this data. Get comfortable with it. Pick the data sets that are most helpful to your clients. And then learn to use those, learn to leverage those in ways that create meaningful and positive outcomes in what might have ordinarily been sort of a helpless situation.
Great. Thanks a lot, Ted. Mercedes.
I think one of the things we all need to also pay attention to is data bias. How is the data being accumulated and analyzed? And how does that apply to you? And then how do you find out more about what data analytics are out there in this rapidly evolving field? I mean, we don't have an IP data analytic commons that is really readily accessible with comps. That's my pipe dream wish, is could I have the comps on comparators? So anyway.
Okay, great. Thanks a lot, Mercedes. And Katie, your final thoughts here today. What do you hope people remember?
Yeah, I would just reiterate the importance of looking at the analytics and finding the ones that are specific to your situation. And I would say what I've learned today from the panelists as well is the importance of using, having conversations with examiners, interviews, mediation techniques when you can, going to the ombudsman. Those were strategies that I learned more about today. So thank you for that.
Good. I thought this was an excellent conversation. We went rapidly because there's so much to cover here, and there are so many good ideas and good tips and strategies. But I think they all the ones that we were talking about here today come back to data. You actually can get some insights, and when you look at the insights, sometimes they're more meaningful in other areas. Like in 1600 with fast track, it's 15% points higher. In certain areas, it's only 5% higher. Okay, so that may or may not be significantly enough to get your client to allow you to do that. But when you look, you don't know what you might find, right. And if you find something that is actionable, it makes the looking for it all worthwhile. And I also think as well, of using this to your advantage for marketing. I think that once you have the client, you can expand your own portfolio within the client so that you can convince them to let you do more because you have a strategy and a plan and can prove that that plan is likely to succeed.
Right.
So that's my takeaway. All right, everybody. Thank you so much for being here today. We really appreciate you joining us. Panel, thank you so much. Thank you to LexisNexis for sponsoring this. And we hope to see you all soon.
Right.
Bye for now.
Thank you.
Thank
Bye.
you.
Yeah.